Good evening, everybody, and welcome to the last but not least panel of this wonderful event. Our panelists, and I would ask you to look at their bios in the program, they need no introduction, will focus on property rights versus liability rules, theories, and practical implications. As we mentioned throughout this couple of days, and in general, you know, this is a very important topic and one when Jerry and Judge Calabresi have been pioneers, and the pressure is on for the panel because we got moved because Judge Calabresi was really interested in listening to this topic. I also want to say something very incidental. I am from Bologna and I use the airport in Bologna very much, even though I don't live there anymore, but my parents do. And I didn't know that the airport is, you know, there is the story of the Calabrese family. And of course, I am very proud, sono molto onorata di compartire la nostra discendenza bolognese, ferrarese con Guido. I spoke Italian a bit, you know, I had to. So without further ado, we will follow the order in the program. My panelists will stick to 10 minutes, 11 minutes. I will give you a little bit of wiggle room. You cannot go beyond 12 minutes. And we start with Professor Cottier from Switzerland. Thank you very much.
Thank you, Irene. I'm truly honored to be here, and I would like to thank you so much for the invitation. I wasn't sure whether I really deserved it, because other than many in the room, I'd actually never cooperated with Jerry. It was never a common project. I was actually pleased to hear yesterday that he wrote one of his seminal articles based upon the India patent case, which I chaired at the moment, so he benefited from the mistakes perhaps we made at the time. But other than that, why should I then come? And the reason I do come is the following. Around the turn of the century, a little bit before, I was on the board of the International Plant Genetic Resources Institute in Rome, Biodiversity Today. And out of this work, I really became convinced that we need to promote traditional knowledge rights here in order to empower rural communities, farming communities, and to have them benefiting also on the IP system, which was largely developed, of course, in the industrial age and with very limited benefit to agriculture. We tried to improve things with geographical indications as a first step. And that was a very, very lonely work at the time, because I used to be a trade negotiator for a developed country, and to come up with the idea that we should protect traditional knowledge caused some confusion among some people. And I was so glad that I then could refer to Jeremy Reichman, the distinguished US scholar who represents the other America, and who writes in the style of Henry James, who actually supports the same ideas. We didn't agree actually on the solution, because you went for a liability rule and I went for a propriety rule with the tip rights, because I felt it's about empowering these communities vis-a-vis the big corporations here in the first place here. But I'm not going to talk about this today. I'm taking another liability issue up, and I would like to do that because I would like to get your feedback on it and the feedback of all of you. And this is something which has been troubling me for recent times. The standard knowledge is that intellectual property rights are private rights. There are negative rights, there are horizontal rights, and they don't really affect the relationship between private actors and the government. At the same time, we have a lot of public policy goals and objectives on the books, which of course involve the governments here. What I see is a fragmentation. We have many areas which belong to private law, and most of the people here would work within this realm. But we also have a lot of provisions in IP which are classical public law. I mean, just a grant of a monopoly in the first place, if you go back to Anne's Act, was a public monopoly granted to somebody else, which was at the time or today, it's classical public law here. And so some of the provisions, they cut both ways. The famous Article 20 on the use of trademarks, I remember when that was negotiated, this was a horizontal issue. We were concerned about tying different trademarks, but we didn't think about government intervention. Just for you, you may correct me, but that was my recollection. But it shows that things cut both ways, and they also have a very strong public angle here. I think we do have a very strong elaborate protection system in the horizontal relations, and most of the topics which are being discussed in this conference, I think, do belong primarily to this horizontal relation, and that has also to do with the epistemic community, which IP is essentially done by commercial lawyers and private lawyers, and not so much by public lawyers here. And when we look at the vertical relation in public law, I think this field is unsettled. I remember when we negotiated in government use, the example was in the United States that the US government could take any patent without informing the right holder, without any compensation, without any information, absolute sovereignty. Of course, this goes back to the wartime, but it was still on the books here. There was an idea of unfettered sovereignty the government can use. And out of the private negative characterization of IPRs, people conclude there is no right to use an IPR. The government, you cannot invoke the right to use an IPR against the government, and you will see that at best, legitimate interests are being recognized and protected. So the question is, which I'm troubling and which intrigues me, is how best to define the relationship between the right holders and the governments who may restrict the use. Should we recognize the right to use as a starting point? I think the issues of increasing relevance. We, of course, know about the issue in the context of health problems, tobacco, but tomorrow it will also be about foodstuffs, obesity problems. Maybe climate change will have an influence, what kind of food we can market in what way, and what does that mean for trademarks here. And then, of course, you have to put this whole thing in the modern wars on technology, and you have to take into account also what authoritarian governments might do if there is unfettered sovereignty to restrict rights here. What does it mean for copyright, for example, if you can just say, we ban copyrights, full stop. We have unfettered sovereignty here. We can do that. We have very little case law on this here. Some of the cases were mentioned already here. And I only want to mention the following thing. When you read the plain packaging case, there is an upside world. You see developing countries, Honduras, Cuba, argue for the right to use. Stronger rights. And you read Australia, supported by Canada and Norway, say, no, there is unfettered sovereignty. We can do as a government whatever we want. And this is interesting to consider. Also, just here, the last case, which is a Canadian case where the government has the view that data produced by geophysical services under licensing have no copyright status. You can't invoke them in the first place here. So how do we define this? Now, I'm teaching mainly international economic law, and I speak here as an international economic lawyer and from a public international law perspective here. And if we look at it from the international law perspective, there is no distinction between private and public law. It's just international law. Even private international law is public law because it's about jurisdictions here. So we can forget about this, and as we go along, we don't rely upon this distinction. Essentially, this is about states, obligations of states, and there may be some derived effects on private, depending on the doctrines which we use before domestic courts here. You see this Article 20, which was at the heart of the plain packaging case. It's not private, it's not public, it cuts both ways, and we have to interpret it here. How do we go about it? Now, the point I'd like to introduce here is that in Europe, under Protocol 1 of the European Convention on Human Rights, it says, every natural or legal person is entitled to the peaceful enjoyment of his possessions. No one shall be deprived of his possession except in the public interest and subject to the conditions provided for by law and by the general principle of international law here. So essentially, intellectual property, I stress that, is not a human right. I think it's a utilitarian concept, but through the guarantee of property, we adopt the structure of interpreting and applying which is being developed in the field of fundamental rights and human rights. So you start off with a right and then you start restricting that right and go through several tests here. And this is essentially what was done and recognized with the Anheuser-Busch case. So I would put before you that this property guarantee, yes, in Europe, at least in Europe, implies a right to use as a starting point. We would have to examine further what the implications in constitutional law are or in EU law, but this is what I would put before you. And that has methodological implications. First of all, if there is a restriction, you have to show that there is a legal foundation. You have then to go through a necessity test, which essentially boils down in assessing proportionality. And if you can't meet this test, there is a liability for compensation under the European Convention on Human Rights. And we can go through the same thing in investment protection. I'm not going to have the time for this. The interesting thing is that under investment law and also under trade law, we deny the right to use, but we recognize a legitimate interest. But with the recognition of a legitimate interest, the balancing of interests is very unclear. You don't have a clear starting point. If you start with the right to use, it is clear as you go through it. And that's what I could demonstrate here. So my point is we need to focus, when we discuss about liability, also about the vertical relationships between the right holders and the governments. And we have to identify to what extent rights can be lawfully restricted and to what extent maybe it results in liability rules. Thank you.
Thank you very much, Thomas. Perfect timekeeping, followed by Graeme Dinwoodie. Thank you very much.
Thank you, Irene. Thanks to Ruth and to Justin and to Irene for the invitation to come participate and to honor, celebrate the work of Jerry. The first academic conference I went to after getting a full-time academic position in the US was Pam and Jerry's event at Columbia. Goodness, a year before TRIPS, almost. It seemed a long time away. And I remember many things about that event, but one I remember was this in the middle of pretty intense discussions over a whole day with what were the giants of the US intellectual property community, continual chuckling from someone, even whether he agreed with you or disagreed, Jerry's hearty, warm, welcoming chuckle that suggested he had an engagement with the idea, whether you were right or wrong, was always a great comfort. As a young scholar, and is now every time I go to a conference, I love Jerry's chuckle. He bobs, he weaves, he chuckles, and I feel like I'm home with Jerry around. Well, my remarks today on the relationship between trademark and unfair competition are prompted by rereading recently Jerry's testimony in 1997 that he gave to the House of Representatives on proposed sui generis database legislation, to which actually Paul referred this morning. Jerry's congressional testimony reflected in part the thinking behind his classic 1995 article, Universal Minimum Standards in the International Lawyer. And that article provides still a wonderful systemic analysis of the structure of the TRIPS agreement and how the TRIPS agreement conceptually fits within the broader international intellectual property system. And as we all know, in the EU database directive, the European Union conditioned protection for non-EU database makers on reciprocal protection in their country of origin. And in his testimony, Jerry argued, and I quote, "There's a reason to believe that the EU's directive material reciprocity clause violates the residual national treatment clause of the Paris Convention on Industrial Property, which is incorporated by reference into the TRIPS agreement." Well, sui generis database rights are, of course, not explicitly addressed by the Paris Convention on Industrial Property, but unfair competition is. Despite the fact that, as Bowden now explained in the guide from WIPO, the rules against unfair behavior are not necessarily related to property at all. And to be sure, Article 10 bis of the Paris Convention barely imposes any substantive particular obligation on member states. It simply provides that, quote, "The countries of the Union are bound to assure to nationals of Paris countries effective protection against unfair competition, which in turn defines as any act of competition countries' honest practices, industrial commercial matters." Well, that general commitment in 10 bis was augmented over time by a couple of specific examples, first in The Hague in 1925, in London 1934, Lisbon 1958. But the latitude that were afforded member states regarding unfair competition remains substantial, in part because of the wide range of understandings of the concept in different national laws. But the residual national treatment clause that Jerry described in the Paris Convention in his testimony encompasses not only formal grants of property rights, such as trademark or patent, but also more amorphous claims grounded in national unfair competition laws. Indeed, Article 10 bis had first been introduced in 1900 in Brussels for that very purpose. It had no substantive content. It was simply to ensure that foreigners were treated exactly the same as locals. Now, that model of international protection that's reflected in the treatment of unfair competition in 10 bis might seem to be a relic of the earlier 20th century. So you had truly minimum, almost zero, standards allowing diverse national laws to treat it, with national treatment being the real structural glue that actually held together the international system. Now, I have to acknowledge that since then, the relatively bare substantive obligations of the early Paris Acts have become much more extensive, much more detailed, and that process culminates in the TRIPS agreement. The trademark section of TRIPS now hints at treatment under trademark law of a number of issues that were formerly a matter of unfair competition law under national law, such as protection of design marks or protection against dilution. Despite that arguable shift towards stronger property rights at the international level, the relationship between trademark and unfair competition may in the last few years have started to reset, both in Europe and in the United States, but in apparently and interestingly different ways. So since TRIPS, European Union trademark law has enveloped unfair competition thinking and brought it within EU trademark law, at different times hardening the property right, at other times softening it. I don't want to go into detail, but you have examples of dilution protection, the types of use, non-trademark use now encompassed by EU trademark law, the reorientation of the defenses provision towards the honest commercial practices proviso that's drawn from 10 bis. But during that same period, the US courts initially moved in the opposite direction. So if you go back to 92 in the Two Pesos decision, the Supreme Court appeared to recognize the effective assimilation of federal trademark claims and federal unfair competition claims. And that was a departure from the earlier 20th century US law, where trademark law was commonly understood as a subset of a broader law of unfair competition. Common law unfair competition protection in the US protected a broader range of subject matter that could be registered as a mark, but required proof of harm, required proof of causation, and the relief you got in unfair competition action was not an automatic injunction, the way you would get in a registered trademark infringement claim. But we may be on the cusp of another shift in US law. The case that I think shows this most clearly, which a couple of people in the room have been involved quite closely with, is Balmora versus Bayer, which is the 2016 decision of the Fourth Circuit. It involves an unfair competition lawsuit brought by Bayer against Balmora under Section 43A of the Lanham Act for Balmora's use of the mark Flanax on pain relievers. Bayer owns the mark Flanax for pain relievers in Mexico and actually throughout Latin America, and had done so and used it since the 1970s, but it didn't sell it in the United States. Partly because it had a very good brand called Aleve, which it didn't want to cannibalize. So it never used the mark here, and never registered the mark here. So it was Balmora, the American company, that actually registered and used it for pain relievers. And their packaging, lo and behold, mimicked Bayer's Mexican Flanax packaging pretty closely. And they made statements in brochures implying that the Flanax brand that they were marketing was the same Flanax product sold in Mexico. The district court actually denied Bayer relief because, having not used the Flanax mark in the United States, it did not possess a protectable property interest in that mark, which the district court read as a prerequisite as an action for unfair competition under Section 43A. The Fourth Circuit reversed, criticizing lower court for conflating trademark infringement with unfair competition, emphasizing this is an unfair competition case, it is not a trademark infringement case. So without going into the doctrinal weeds of the standing rule from the Lexmark case that the Fourth Circuit used to try and construct unfair competition claims, the framework that they adopted in the Balmora court decision has the potential to dramatically reshape US trademark and unfair competition law. It recognizes an unfair competition law that is potentially broader than trademark law, but that is limited by proof of causation and harm, and which might contemplate a broader array of remedies. And that Lexmark framework has been urged on a number of courts other than the Balmora court over the last 2 years. So we arguably see a resetting of both sides of the Atlantic of the relationship between trademark and unfair competition. I think that raises really interesting normative questions at the national level, and there are a number of scholars in the US, including notably Rebecca Tashanet here at Harvard, who are thinking through what the optimal mix might be of those different forms of protection. Other scholars have argued that we maybe should treat product design marks under an unfair competition rubric, which would include relief that require the second comer to adopt measures and incur costs in differentiating and advertising its product, but wouldn't prohibit the second comer from using the protectable design. However, for those experiments on either side to work, there has to be room within the international system for them to be tried. The international system has only periodically addressed the relationship between different forms of protection that states might offer. And the tortured history of Article 2 of the Berne Convention, which is beautifully explored by Jerry in his two pieces in the 1980s, which Peter, I think, rightly described this morning as monumental pieces of comparative law, might explain why the TRIPS agreement barely tries to regulate the dynamic between different forms of protection. At the national level, whether you wish interacting or accumulation of different rights depends in part on whether you think there's some end running going on of intentional limits in one regime by protection on the other. At the international level, choosing one form of protection over another might be seen as an instantiation of the principle that's in Article 1.1 of TRIPS, that members, quote, shall be free to determine the appropriate method of implementing the provision of the agreement within their own legal system and practice. Now, we've clearly moved beyond the national treatment-driven model of the late 19th century, but in a world where the international system now includes 180 countries of very different legal traditions, that 19th century model, albeit with much greater substantive obligations later on top, still has a lot to commend it. And within reasonable limits, there surely has to be some room for different countries to tweak the different tools of trademark and unfair competition law, as both the US and EU are apparently trying to do. Without seeking to jettison or ignore the substantive obligations that have clearly been imposed by international instruments in the intervening 120 years, where there are ambiguities in the text of TRIPS, and I think there are plenty, those questions will need to be answered with an eye to the kind of structural analysis of the entire system that Jerry conducted in his Universal Minimum Standards article in 1995, and then informed his analysis of the EU Database Directive. Thanks.
Our next speaker requires, again, no introduction, Christophe Geiger from CP Strasbourg.
Well, thank you. First, I'll start by thanking you, Irene, Ruth, and Justin for setting up this wonderful conference and for inviting me. I've always been interested in non-exclusive uses of copyright law since my very beginning at my PhD in order to promote fairness and justice. And here I have to particularly thank Jerry for inspiring me very much and leading the way in this reflections on non-exclusive uses, and in particular because I was in France, and as you know, in France, exclusive rights tends to be seen as the act of God, and questioning the exclusive rights is like being a heretic. So I was looking for scholarship around the world to actually support my views and see and tell, or at least try to prove that they are valid and possible also legally. At this point of time, when I was a young scholar, I was kind of exposed to your scholarship, and it really inspired me a lot, like Pam's and others, to be questioning a little bit this act of God. I didn't make much friends in France, actually, where I'm still a bit considered as being a heretic. But anyway, all right. So this is why I'm going to talk about it today. A little bit on the empowerment of remuneration rights in copyright law. Because when actually, I mean, it's quite obvious when you look into the rationales of copyright law, meaning there should be providing incentives for creators to create by securing them a fair remuneration for their work. When you look at it a little bit, like very intuitively, you see like, okay, it should be protection, it should be access, but is it really doing the job? And you seem to see, and many studies have shown this recently, that creators seems to be a little bit the loser of the system because they're most of the time not really remunerated, and they're facing more and more hurdles when they want to create. And we see actually that this leads to a huge loss of acceptance of the copyright system. There has been some studies, it's not like by the Pirate Party or something, but a very serious institution in Europe, the EUIPO, has made a survey asking citizens between 15 and 24 years old what they think about the copyright system, and basically 50% of them said to consider illegal access to copyright material as an act of protest against the system. So I think this is very worrying, and it forces us to actually question some of the assumptions. So here is one of the findings that has been recently put out by a group of researchers at the University of Glasgow that showed basically that only the top-selling authors are rewarded by the system, and that we have to look for other mechanisms to remunerate creators. But on the creative side, when you put, for example, the fact that derivative creations, like derivative works, are subject to the exclusive right, if you test that against the jurisprudence, the case law of the European Court on Human Rights on freedom, artistic creativity, and freedom of expression, you see that it's highly problematic. It might even be unconstitutional to subject derivative creativity to the exclusive right, because it gives the power to some right holders to say no when you want to create. And this is really problematic, in particularly with regard to our history in Europe, about degenerated art, etc. And we see that derivative works are subject of very strong litigations, be it in the US with fair use or in the EU around fundamental rights. But what is interesting is that actually this incentive function, this speech function, is very much shared by limitations as well. So we know that limitations are also there to enable future creativity. And recent studies have shown that there is an economic benefits to it. I mean, the work that is done by Sean at American universities shows that strong users' rights have very beneficial functions. But there is another function that is, I think, underexploited with regard to limitation, is the remuneration function. Because it's maybe a little bit a feature of Europe to attach a limitation to many of our a remuneration to many of our limitations. And there has been some study made by WIPO, for example, around the remunerations that are paid in respect of private copy, and that's 600 million euro per year. So here is my assumption, basically, that if you have a very well designed limitation system, this can have very beneficial consequences on innovation and creativity, but also readjusting the balance in favor of creators. And this is, I think, a little bit overlooked in the debate. So here I'll be very brief because I don't have much time. We know a statutory remuneration, that's not something new. You have them in international law. And you have also limitation-based remuneration rights. So I'm browsing very fast through this. The statutory remuneration we know from international law in connection with resale rights, right to remuneration for rental, etc. That's not what I'm interested in, and I'm really interested in the limitations that are generated by limitations. And here what is actually quite interesting is that basically states have a very wide policy space to basically decide how much of the remuneration goes back to the creators and how much is attributed to the original right holders. So basically, all right, so I don't really have much time. All right, and so I'm following on this idea. It turns out, and courts have recognized this in Europe, and major courts in Germany and in Switzerland, that basically limitation-based remuneration are in many cases much more interesting for authors than the royalty payment they receive from their contractual parties. It is also interesting to see that, for example, Germany has considered, and in the EU with regard to rental rights, that limitation-based remunerations are it cannot be waived. So, of course, your exclusive rights most of the time are given away by contracts, but these remunerations stick to the creators. And this is quite interesting, I think, as a regulation tool. Here, a little question about terminology. Now, all these limitation-based remunerations are often described as compensations, levies, liability rules, of course. I tend to think that in the European context, or if we want to push for this agenda, we might more call them remuneration rights or limitation-based remuneration claims, because we get away from the idea that it's a damage that needs to be redressed, but it's more like, look at these limitations as a way to remunerate creators differently. So how can we secure this fair remuneration? That was the question that was raised by Judge Calabresi. By the way, who do we trust, basically, on setting this fair price? We can establish it in the law. That's not very nuanced. We can have a special body, a court, trying to set up this fair price, or it can be negotiated. And when what I suggest is when parties cannot agree, to have a little bit more the possibility to mediate and to have recourse to alternative dispute resolutions. So here I'm doing some work with some colleagues at the University of Strasbourg to set up or to conceptualize an independent regulation authority that would be possibly also a way to mediate claims that are generated in the context of remuneration rights. And I'm working on, but I don't have much time to go into this, into a proposal to implement a non-waivable right to equitable remuneration in the context of derivative works, but time is up, I see. In any case, again, thank you very much, Jerry, for having inspired a lot of my conclusions. Thank you very much.
Thank you very much, Christophe. The next speaker, I asked Martin Senftleben to go next because he has slides while Anna doesn't, and I am very afraid that the machine will work now and then fail later. To avoid any issue, we will use the machine now and then, so you know to maneuver that. Okay, great, yes. And going off on Keith's observation yesterday about Jerry taking notes on the yellow paper, I have a privileged view here. I can see Judge Calabresi taking notes on a yellow paper too. So it's really, really cute. Sorry. Professor Senftleben.
Yeah, well, first of all, thanks, of course, to the organizers for inviting me. Then I can't thank Jerry enough for all the inspiration, so I join all the others in saying, well, whatever I did on TRIPS at the three-step test and these things would not have been possible without your groundbreaking work in that area. And so it comes as no surprise that for 1.5 days we have now tried, and I think we were quite successful in painting the picture of an open-minded, supportive, and generous scholar. And so I thought, well, at the end, what can I add? So, well, I think what I can do is I show the dark side of Professor Jerry H. Reichman, because from my experience, I mean, he can be rigorous, ruthless, and rather unfriendly, but this only, I mean, this dark side only comes to the fore when he is confronted with nonsense. And, well, I mean, in particular, it's when he is confronted with incoherent policy making, and in particular, incoherent legislation. And I can tell you, we have seen quite a bit of that in the European Union lately. So I'm referring to the new directive on copyright in the digital single market. And actually, when I first told Jerry about it, it was at the Global Congress last year held in Washington, and so we met, and Jerry said, so what's new in Europe? And so I said, well, we have these wonderful new piece of legislation, another pearl of EU copyright legislation. And you know what? The Europeans decided to put an end to the traditional safe harbor for hosting, so platforms for user-generated content, in particular YouTube, no longer enjoy the traditional liability shield that was always available in the EU, and that is still available in other regions like the US and also in Asia, like in China and so on. So the first reaction I got, and there you see the dark side, the first reaction was, but that's insane. Yeah? And then, I mean, I'm really not known as a big supporter of this new piece of legislation, but I mean, being confronted with your reaction, I try to explain the whole thing. Like, well, you know, the Europeans are not completely crazy, at least, I mean, whatever you think about how it is made, in terms of legislative technique, at least the underlying objective is laudable, because what they want to do is they want to make those platforms pay in order to ensure that the individual creators whose works are used get some remuneration, and these platforms are not just populated for free without any money flowing back to the individual creators. And then the second reaction I got was, but that makes no sense. I mean, not the objective makes sense, of course, but the way of achieving this makes no sense. And when I was then asked to contribute to this Jerry Fest, I thought, well, I think this is a wonderful opportunity to me to conceptualize the whole thing and explain why it does not make sense in the way it is done. And I think it makes no sense when we approach the thing from the property rule, liability rule perspective, because what the Europeans did was opting very clearly for a property right. So it was a full-fledged property rule approach. We see this in Article 17. This is the new provision that grants a very specific exclusive right with regard to online content sharing service providers. So we have wonderful new terminology as well. So basically this is YouTube. These are the bad Google guys. They have to pay. And how do we make them pay? Well, we say whatever happens on the platform is, as 17.1 says, an act of communication to the public or an act of making available restricted acts under EU copyright law. And so you are directly liable whenever a user uploads something that infringes copyright to your platform. I have left the strike-through language in the text. Of course, it's not in the final text, but I wanted to make visible what has been in the drafts for a very long time. So the traditional knowledge requirement, which we know from the safe harbor provisions, was in the provision, but has finally been omitted. So the new legal framework is very much based on this property rule, this property rights approach. So the rights owner can say no. And well, it gets a bit more nuanced because the platforms have two options. They can opt for licensing, of course. Well, that's logical. If otherwise you are an infringer, you can ask for a license. And if you don't get a license, then filtering can be an alternative measure. Filtering in the sense of prohibiting any infringing material to appear on your platform. Filtering is a word that is not used in the legislation. The legislation refers to ensuring the unavailability of infringing material, but of course, I mean, practically speaking, this will be filtering. And actually, I think whether you manage to get a license or not, filtering will be all over the place. Because what we hear from the industry nowadays is that, I mean, the music industry may be able and willing to grant rather broad umbrella licenses, but the audiovisual industry, for instance, is definitely not. I mean, they want to keep their exploitation cascade, cinema first, then pay TV, then regular TV, then, I don't know, Netflix at some point. So they are not willing to grant general umbrella licenses. So whether the license is more limited, then you need filtering to police the borders of the permission you have received. And if you can't obtain any license, then you have to filter anyway. So filtering will be all over the place. And this is my primary point of concern. There is so much reliance on industry cooperation that I think this legislation has totally forgotten about the public policies that underlie this particular area. I mean, we had all these writings about the revolution of user-generated content, content production getting more democratic, everybody being a creator, free to disseminate certain materials on the internet and so on. So I think the results that we get on the basis of a property rule are quite disastrous. And so your first immediate spontaneous reaction, ruthless, I would say, was totally justified, I would say.
I moved a little bit the other way.
Yeah, I also
understood something that I didn't understand then that I'll tell you.
Okay, very good. So, well, I also try to move. I'm getting older and milder. So this can't be the final word because when we look at the alternative liability rule, then we must admit there is some space in the legislation. When we look carefully, there's a hook, starting point, for introducing a more liability type element to the whole thing. 17.7 says, whatever filtering mechanism is applied, works or subject matter and use of it that is covered by an exception or limitation, this should remain free. So you can upload parodies, you can upload quotations, and so on. And this could be a starting point for an alternative approach. For this alternative approach, first of all, we would have to explore the maximum space of forms of use that we can bring under the scope of these exceptions and limitations. But honestly speaking, it's not just about licensing and filtering, it's also about statutory exemption of user-generated content, which I would call the privileging approach. From a US perspective, you may now say, okay, that's a fair use thing and so on. We can manage to do this. In the EU, this is not as simple because we have broad exclusive rights but a closed list of permissible exceptions and limitations. So we have to find a heading in the established list of permissible exceptions and limitations that helps us doing this. And there's 5.3K for those who are interested in the technicalities of EU copyright legislation that entitles member states to exempt use for the purpose of caricature, parody, or pastiche. So I have highlighted pastiche here because, well, I don't know about the specialists here in the room, but nobody really knows what pastiche is. It seems to, I mean, the roots of the word seem to be in Italian, I guess. Pasticcio.
No, it's français.
Français. Très bien. But in any case,
it's Latin.
In any case, I would say this is pastiche. So pastiche means a mashup, a medley of content. So this is the funny animal video where in the background you have some protected music and so on. Pastiche is also all types of content snippets put together to make a statement, an ironic play or something with pre-existing material. And I think that the Court of Justice could play a crucial role in developing this concept in this direction because the court has already harmonized other types of concepts in that area. So we have a harmonized type of humor in the European Union nowadays because the Court of Justice told us in the Deckman decision that from an EU harmonized perspective, parody is an autonomous concept of EU law. So pastiche could become an autonomous concept as well. And then the Court of Justice could say these types of user-generated content, like the funny baby videos and animal videos and so on, this falls under the concept of pastiche. So in a nutshell, I think there is room for still balancing this a bit by introducing a liability rule into the whole system. The legislative model would be very much based on private copying levies model. So users enjoy the freedom of remixing pre-existing materials, but then the platforms like YouTube would have to pay levies, as we could say in EU terminology, and collecting societies would pass on the money directly to individual creators. So we would need a new collecting society. You could say this is a concrete application of what Christophe just introduced as a more abstract concept. I'm out of time, but I would like to add a last little thing. The important thing here is that this also changes our perspective on filtering. Filtering will happen anyway, but it's the question whether in implementing filtering mechanisms, you only ask the question, is there something protected in the upload and then it must be filtered out? Or you ask another question, namely, is there something that justifies the upload? So is there some added creative element of user creativity that could justify the upload? So in other words, it's not just, oh, there's something protected in it, so it's out. The question is there something protected in it? Okay, might be problematic, but is there some user-generated creativity in the thing that could justify the whole thing? And then it should not be filtered automatically. Well, yeah, we can't say, in EU policy debates, you can't even say fair use any longer, so we have neutrally to refer to flexibilities or something. I'm out of time. If you want to read more about it, it's the Bermuda Triangle approach, so thank you.
Thank you. Thank you very much. And our last but not least speaker is Santos Rutschman, and I think we want to close that. Yeah, I want to put the slides, the big slides, the Jerry Fest.
So as a former student of Jerry and as a follower of Jerry, I have no slides whatsoever. I don't take notes on a yellow pad, but I did paint my law school office yellow just to, evoke the feeling of entering Jerry's office when I was at Duke. All right, do I leave this on? Is that it?
Yes.
Okay. All right. Thank you, Irene, so much. Thank you, Ruth and Justin, for the invitation. It's a delight to be here. Thank you, Jerry, for everything. Microphone. Thank you, Jerry, for everything. And thank you to this community that I'm lucky to be a part of. I'm very mindful that I'm the only thing standing between you and two types of goods that Jerry and probably many people in this room value, food and wine. So I'm going to do away with the colorful jokes I had about the words in the title, Cathedrals, Tulips, and I'm going to go straight to a proposition that cuts directly into the issues of liability versus property in a very particular field. In his first, I think the first intervention in this conference, Terry Fisher asked, how do we implement liability, Jerry? Can you tell us how to do it? And today, Judge Calabresi said, ask about the price or the assessment, who determines that. I don't have a grand theory of liability, but I have experience with vaccines. And even though I thought, leaving Duke, that I would promptly forget everything about liability, when I worked for the WHO in a lot of licensing agreements, looking at them and the partnerships that were bringing vaccines for Ebola and Zika potentially to market, I found myself in a situation in which I thought, oh gosh, if only we had a liability regime for these types of goods to come to the market faster. So I'm going to tell you a couple of stories, not stories, I promise, snippets to illustrate what the problem with vaccines is. By vaccines, I mean vaccines for infectious diseases, so things like Ebola, Zika, the things that tend to be on the WHO list of emerging pathogens that are capable of triggering massive outbreaks, but a simple vaccine, which in itself is very, very simple technology, could prevent by and large. And I'm going to explain how intellectual property can actually delay us bringing those vaccines to market and what can be done about that. And surprisingly, the answer is liability. So first, and very quickly, and not doing full justice to these stories, the snippets. Ebola outbreak, which all of us in this room remember, the lead vaccine candidate was developed by the public sector in Canada and licensed to a small company in Ames, Iowa. If you've never been to Ames, Iowa, don't go, but trust me, it's extremely small. So was the company, effectively incapable of really developing the vaccine. They acquired it for $200,000 US dollars. The outbreak started. There was funding for the development of the vaccine. You'd think they would be motivated to push the vaccine through clinical trials and the regulatory later stages of regulatory pathway. They didn't do that. They sat on this vaccine. We now estimate 3-4 months waiting for a deep pockets player to come along. The name of that player is Merck. They did come along with a package of 30 plus 20 million US dollars just to acquire the technology on which this small company had done no work whatsoever. Once Merck came along, they were able to start clinical trials in under 2 months. So that's the first snippet. Second one, close in time, Zika vaccine. Leading Zika vaccine candidate developed by the US Army, funded by different US agencies, a lot of them involved in national/biosecurity work. The Patent Act says when you transfer a vaccine or anything federally funded out of the public sector and into the private sector, which you have to do because the public sector really lacks the capacity to develop fully these vaccines, you have to abide by a series of rules. You have to at least attempt to negotiate a non-exclusive license. You have to give preference to American companies. There's a number of rules that you have to comply with. The Army didn't do that. They went straight for an exclusive license with a large French pharmaceutical company. People like Senator Sanders, Jamie Love, yours truly wrote to the Army asking, we're looking at this notice. Why is it that you're not attempting to license this non-exclusively? What are your pricing terms? We all got the same letter that some of you might be familiar with, saying, we've never attempted to do that. We don't have the know-how to engage in those negotiations, which I thought was awful and striking at the time, that they would admit to violating the law and lacking the know-how to engage in these types of negotiations. To finish the snippet, what happened? This French pharmaceutical company, which had gotten grants from other agencies, other US agencies, was counting on continued funding in addition to the exclusive license from US agencies. When the outbreak began to subside and that stream of funding went away, they said, well, we're stopping all work on the vaccine. So there was our most promised vaccine candidate, and all work stopped on it. It hasn't been fully developed to this day. Let me take, for a last last couple of stories, the outbreak element away and think about vaccines for things that don't depend heavily on the income attached to an outbreak to go normally through the R&D pipeline. So first case, CMV virus, cytomegalovirus, should not preoccupy most people in this room. It's in the herpes family. If statistics hold true, about half of people in the room suffer from it and will never notice anything unless your immune system is compromised. So HIV-infected populations, newborns, even fetuses can be severely affected by this virus. We don't have an approved vaccine for CMV. We do have the ingredients to make the vaccine. Basically, you need three things. You need two proteins and a different type of molecule. They've all been successfully developed. They're scattered among different companies. I've talked to people at all of these companies, and they all agree that because the clinical trials involving the scatter technology were successful, if we were able to put this technology together, which again, not a very difficult thing to do from a scientific perspective, just like it was not hard to develop the Ebola vaccine once we had the money and the will to do so, we could bring that vaccine to market. Because the market is expected to be very, very small, these companies, although some of the scientists working on projects to develop molecule 1 and molecule 2 and molecule 3 are on the board of some of these pharmaceutical companies, it's just not a strategic priority for them. So even though a smaller company could bring a CMV vaccine to market by just using this technology, we're facing a scenario of 1, technology dispersion, and 2, intellectual property rights that completely block the pathway for any innovation in this particular field. Last one, sort of the reverse of all this, we had an FDA-approved Lyme disease vaccine in the US market. We don't anymore. Vaccines are a special breed because they're not expected, the ones that I've been focusing on, they're not expected to generate a lot of revenue. So between that and the mistrust that sometimes attaches to vaccination, that vaccine was stopped being manufactured because there was low demand for this, and to this day it has not come back to market. It's also patented, so you depend on the goodwill of the manufacturer to bring it to market. So 4 different snippets. I would like to reemphasize this is vital technology that furthers public health goals, and all of it covered by intellectual property rights, but very, very basic technology. We're not talking about the types of vaccines we don't have yet, like DNA vaccines and other kinds of goods. We're talking about very important, very valuable from a social perspective technology that just doesn't come to market either because of technology dispersion, rent seeking, all behaviors that are enabled or at least accentuated because of the existence of intellectual property rights. So, since I've left Duke, I've been trying to use Jerry's scholarship and Judge Calabrese's as well to think about ways in which we could solve this problem. I don't think that from a political economy perspective, we can implement too many ad hoc liability regimes. But if there's one area in which such a regime would make sense, I think this is the one. I think most people in this room, if not everybody, would agree that it would be a desirable goal to bring more vaccines to market. There are ways in which to carve a liability regime in which we could even restrict the components ex-ante that would be subject to the liability regime. And this could be done through legislative intervention. One very specific example that I have in mind for science geeks, adjuvants, maybe not a good idea to subject to a liability regime, but the main components of vaccines, if attached to this list of diseases that the WHO says they're going to cause big public health crises in the near future, and the technology is relatively simple and fairly easy to master, I think those would be would embody a good and realistic approach to a liability regime. Even before today, I've spent some time thinking about some of the practical implications, who administers this regime, who decides what the assessment or the amount should be. One of the ideas I've been working on is that we are talking about a very specific type of good. So one or two agencies that come to mind because of their goal of furthering the public interest. We could talk about the CDC. We could even talk, perhaps not so adequately, about the FDA, the NIH. They could serve as facilitators to determine the assessment, the value, whatever you want to call it. I think that if we did this through legislative intervention, and I'll just remind you that through legislative intervention, we made the FDA award vouchers to companies that get FDA approval for certain diseases that align fairly well with the types of diseases I've been talking about. So I think that we could consider the possibility that if the legislator were to introduce a flexible formula that we know ex ante, then ex post, and very, very quickly, whenever there's a smaller company that is actually interested in innovating in this not so profitable market, we could have an agency being the locus for that type of discussion, and it could do it fairly efficiently. Thank you very much.
Thank you very much, Anna, and thank you to all the panelists. We are a bit late, but the panel started late, so I assume we can have around 5 to 7 minutes for questions. Please, I would suggest that we collect questions, and then I would like to give each panelist just a very short time to react to the question. And I would love if somebody would volunteer in moving around the mics. Yes, thank you very much. Judge Calabresi would like to. See, perfect.
I don't know how much this is a question or a comment. In my most recent work, in my most recent book, I've been emphasizing the problem of merit goods, that is, goods where when they are allocated according to the prevailing wealth distribution, there are significant moral costs to other people. There's typically the sale of kidneys or things like that. It's not that we're against it necessarily, we might be, but we don't like the idea of this being sold and that. It seems to me that there is a strong analog to what is going on here. It is not just the question of whether you want a liability rule or limited remuneration, but what kind of limited remuneration or liability rule you want in certain things for certain things, depending on the cost of having that go instead by a pure market. And that the difficulty is deciding who ought to decide what the differences are in different areas. If you then look at the other side, that's also true in terms of a person who is producing the intellectual property. Because for some people, the monetary is relatively unimportant and doesn't have many benefits. They care much more about having widespread. So that if you break away from here is property rules and here are liability rules, but you ask yourself of what level and what kind of payment, then you're focusing on the issue. And that ties up with what I'm working on, so I think it's important.
No, please, please. Jerry?
I had a question for Martin. If I got it right. I asked. I was inspired by your ad hoc explanation of this. The new approach that you described was the old approach that the European Union brought to the negotiations of the WIPO Copyright Treaty and was rejected for notice and takedown. So the question is, why is it now suddenly coming back, and what's behind it? And I got the impression that what's different about it is that the hosting platforms have begun to exploit the materials that are exploited on them and have become players on the actual exploiting copyright market, not just simple hosts that perform services. And this raises a very serious question and makes a lot of sense for why they're moving away from notice and takedown to something much more aggressive. Am I right in that they're starting to play the game? They want a piece of the action, so they want to become copyright de facto producers.
Marquita,
Thank you.
and then
Just a brief question. So a lot of what we talked about today is about greed, right? And reacting to greed, and whether we think about the EU directive or questions about compulsory licensing of pharmaceuticals, right? The underlying theme is greed. And I wonder whether legislating against greed is a good idea, because we must legislate for all copyright patent owners, right? Not just for the greedy ones. If we switch to liability rule as a reaction to greed, we have to figure out how to make some kind of differences between the greedy ones and non-greedy ones, maybe based on other criteria. But then you have to have an arbiter. You have to have somebody who will set the price, right? Somebody who will decide. And there, I wonder whether we should be somewhat cautious and also skeptical. And certainly, we had a bunch of countries that were operating on sort of a liability rule that had regulatory agencies setting prices, and the experience was not good. So maybe we should learn something from that.
Yeah. I'll give it to Henning, and then
Kat also has...
yeah, I don't know if we can get to that too, or we see. 1 second. Yes, please.
Okay,
Justin will tell me. Can I take another one? No. Okay,
just a brief comment, Thomas. I really liked your discussion, especially this fragmentation in international law on this private-public side. So on the right to use, I think we need to be discussing in relation to what? Are we discussing the product and service which incorporate IP as a holistic thing, or just the IP subject matter? So on the former, the product and service, we of course have gut and guts, market access and other types of rules. On the latter, I think if we only look at IP subject matter, the existing agreements leave it to the domestic law and only impose, in that sense, a negative right. And if you just look at footnote 3 to the Article 3 of TRIPS, right, protection in that sense is defined as including a range of things, but only used in the sense whenever TRIPS actually specifically addresses use, like in the case of Article 20. And that exactly addresses this, I think, vertical relationship as well, right? And Article 17, Byrne, I think, confirms it. So I think we need to look more specifically of what we're talking about when we're talking about the right to use. And investment protection and property protection would, I think, incorporate this more holistic way as understanding as well. Thanks.
yes.
Kat has been waiting to ask the question, and he's promised to do what we senior.
I am very happy to give it to her, to us, to have...
Promised to do what us senior scholars don't, less than 60 seconds.
yes, please.
I promise to be really quick. This is
No,
a question,
take your time, don't worry.
this is a question for Martin. The exception within the new copyright directive for user-generated content that you outlined, is the exception for UGC not rendered obsolete by the fact that all of the filtering algorithms employed by platforms essentially just flag content that digitally fingerprints with content within their reference database and doesn't engage in any sort of analysis of whether or not a specific video uploaded by a user does fall within any of the exceptions under under EU copyright law, so whether or not it is a parody or a pastiche. And then my second question is, as the technology expands and we have things like deepfake technology that will go beyond the categories that the EU currently provides for, like pastiche and parody, how will the platforms deal with that?
Okay. Okay, so the panel, I would like to ask everyone in the panel to respond. You take less than 60 seconds, possibly, and then, so you have more things to talk with your fellow Congress women and men at dinner. And so we start with Anna.
I'm just going to say very briefly, Marquette, I don't know that we legislate directly against greed. I don't think that might be the best operational concept. I'll just say that in the field I was talking about, biotechnology, we already have at domestic levels particular implementations of patent regime and jurisprudence. It might not be wonderful regime. Dan Burke, famously called it clockwork lemon, but we're figuring out how to tailor, the rules that we have better to patentable technologies, and I think that discussing liability is part of a much larger conversation. And if I have 20 seconds left, I'll leave them to Martin.
Oh, wow. Well, I get back to your point about competition of these platforms. Actually, I think you are right in saying the starting point is very much the perception that platforms like YouTube become really serious players and they don't pay the same licensing fees when compared with other providers like Spotify or Netflix and so on. On the other hand, what is now happening in terms of legislation can lead to them becoming even more active in producing themselves. Niva Elkin-Coren has pointed this out in a draft article that you find on SSRN, for instance. She says, well, if YouTube and other platforms in this category don't get the necessary licenses, they have to think about other ways of populating their platforms with fresh content every day, so they may become producers themselves. And they have a large outlet already. So if you wanted to see this legislative reform as a step in order to power them as producers, you might have exactly the opposite effect. And with regard to your comment on the exceptions, that's the very risk, of course, that the exceptions become irrelevant because it's all about filtering. So this is why I think that the exceptions logic, what I just labeled as, let's say, the liability rule aspect of the whole thing, this has to be implemented in the filtering logic from the very first moment. So we need filter systems that do not only ask, is there protected content, and then you are out. We need a system that asks, okay, to which extent is here something that we can identify as protected, and to which extent is here something that we can identify as not matching any protected content. And then I think the system should be able to say, if there is 30% that cannot be matched to any pre-existing content, then it's not a clear case of something that has to be filtered and it should go through, for instance. So that's the approach.
Thank you, Martin.
Yeah, so very briefly, because it's late. So just basically, who are to decide what's to fix the price? In a particular context of creators, I have been working a lot with authors, and one thing that emerged from the discussion is that they don't like to litigate, and they don't like to litigate. They don't have the mean to litigate. They fear the judicial system. They're very much afraid of it. So I think courts cannot be necessarily the answer in this particular context, even though they might be the most independent in the particular area. So this is why I think we should explore this idea of regulation authorities, independent regulation authorities, also because these authorities could conduct market analysis, potential economic studies, best practices, model examples for creators that they could see this is protected, here you have to pay, etc., and make some clarity and also provide some alternative dispute resolution mediation on a very low-cost basis in order to be able to create, for example, derivative works. So I think this is something that is totally underexplored in Europe, at least. There are some boards, like for example in Canada there's the copyright board, sets tariffs, and it's quite efficient actually to defend authors' interests. I think we can inspire us from this kind of experience.
Just briefly, just to pick up to respond to Judge Calabresi, in terms of the shift that I was mentioning in the Fourth Circuit, it fits very well with your instinct that there's a need to identify the costs. And the liability approach allows us more flexibility, more granularity in doing that. One of the impetus, I think, behind a series of litigants and amicus who were pushing that particular framework on courts over a 2-3 year period was the premise that there were a lot of trademark cases automatically because of the label property resulting in injunctive relief when the harm was non-existent and there were no costs. And in fact, the framework that the Fourth Circuit brings in by allowing us an examination of whether the plaintiff is within the protected zone of interest and whether there's a causative link between that and the conduct of the defendant allows a measurement of the extent of any harm that would allow us to make the kind of assessment that I think you're arguing for.
Well, thanks, Henning. I think that the issue here is how does Protocol 1 of the European Convention on Human Rights affect the interpretation of the TRIPS agreement? Is that to be considered part of domestic law because it needs to be taken into account, or is it international law and then subject to domestic law? So I think these things need to be worked out. And the same thing is with investment protection, where we recognize a legitimate interest to use already. How does that affect the interpretation of TRIPS? There's really a question mark.
And so with these, I would like if you could join me in thanking the panel. There is much more to say about property versus liability rules, and I think these, like all the topics that we have been discussing throughout the day and yesterday, will continue to be a topic of discussion at dinner, and wine, food, and these topics. And so with that, I think we are ready for the closing statements, and I would like, no, we don't do closing, yeah.
We have no closing statements except to thank you and to tell you that those our honoree and our speakers are coming to a dinner. Professor Okediji has been working on the arrangements and wants to make some announcements. But on behalf of all of us, and we are incredibly thankful that you came. We're almost as thankful that you came that we are thankful for Jerry. And with that, Ruth will tell us a little bit of what each of you needs to know for dinner.
But before she does that, may I ask everybody to
No singing, Irene.
No singing, to really thank Justin and Ruth, because they have done.
So dinner. Let me just say thank you again to everyone. Dinner, you all have the instructions in your email, and I will be judge.
I take care of it.
We already have arrangements for you and the judge.
Yeah.
So.
Yeah. Should Benedetto, don't worry.
So thank you again. Have an awesome evening, and safe travels back, everyone.
Thank you again.